Hi, my name is Richard Elliott. I'm the Director of Professionalism and Ethics at Mercer University School of Medicine. I'm also an adjunct professor at the Mercer University Law School. We're here today to talk about selected issues in psychiatry and ethics, and this lecture has been prepared especially for third year students at the Mercer University School of Medicine. The topics we're going to cover today include involuntary hospitalization, boundary violations. What are these? When might they arise? A few selected topics on confidentiality and privilege, especially how to respond to a subpoena and what is the Tarasoff duty. We'll talk about capacity and informed consent and exceptions to those. And just a few words on the insanity defense because I don't know how else to put this into the curriculum, but it is something that psychiatrists and other physicians get asked about from time to time. Let's start with a case. I'd like you to think about this. You're working in an emergency room. It's about 10 o'clock at night in January in Macon, and police bring a woman in who's walking the streets in her nightie. She's singing hymns. She has insulin-dependent diabetes mellitus, and physical exam is hard to do because she's refusing medical care, but she appears very thin and her right foot is dark in color. She insists on leaving so that she can bring the, quote, word of the Lord, unquote, to the people. What do? Think about this for a minute. Here's some options. You might offer her food and a beverage, probably warm, but not too hot. You have to think about somebody who might get agitated and what she might do with that beverage if she takes to not liking you. You might negotiate with her for an overnight stay. Just remind her that it's cold outside and coming in the hospital overnight might be a good idea. You might offer her some warm clothing, maybe clothing to protect her dignity. You might try to find out where she lives, who her contacts are, perhaps through her church or wherever she's living, and get permission to call them so you can get a little bit more information about her past. You might consider any of a number of options, but if in your opinion you think she needs to be in the hospital because there's some sort of danger to her, then you might consider what in Georgia we call the 1013 process. And we're going to talk about that a little bit, but just keep in mind that if we're going to deprive someone of their liberty, even if we're doing it in what we think is her interest, we should explore all the other opportunities that we can first. Well, the 1013 form looks like this, and we're going to talk about the sections in some detail. These are references to the official code of Georgia annotated, and if you put OCGA, or Official Code of Georgia Annotated, in your search engine, you'll be able to pull up the sections of this. So look for these chapters in the Official Code of Georgia Annotated. And you'll end up filling out these forms. I'll note later that a number of people can complete this. Physicians, not just psychiatrists can, psychologists, licensed clinical social workers, advanced practice nurses like clinical nurse specialists with a mental health specialty. It says, I certify that I've personally examined the person and they appear to need involuntary treatment because they are mentally ill and a substantial risk of imminent harm to self or others, or unable to care for themselves. And then the rest of this is documentation of the mental illness, threats of violence, or unable to care for self. Well, here's some key points. As we said a minute ago, look for any way you can to persuade a patient to come into the hospital voluntarily if you think that's really what they need. If you're not prepared to let her go from the emergency room, see how you can protect her without going through an involuntary process. But if you're forced to use an involuntary process, the 1013 is the first step, and it's really for evaluation. It's to help you get more information on her background, circumstances, and you can use this time to begin to stabilize her condition, whatever it is. Now, for substance abuse, as opposed to mental illness, there's an analogous 2013 process that you can use. I've only used it a handful of times. Most of the time, I find the 1013 works pretty well, but it's good to keep in mind. Now, do note that in that form on the previous slide, it says that your findings are based on a personal examination. That's critical. Personal examination doesn't mean you have to do a rectal exam on the patient. What it does mean is that you actually have to eyeball the patient, you have to attempt to engage them. Sometimes they are so agitated, violent, they're naked, throwing feces, that the best you might be able to do is to look through the window of a seclusion room, for example. Other times you can engage them more directly. That examination has to be done within the preceding 48 hours. But you have to have a personal exam. You can't simply complete the 1013 form based on what other people have told you. That's one of the few areas where there is liability associated with the 1013. And as I said a minute ago, a number of people can fill this out. It's not just psychiatrists, but other physicians, psychologists, social workers, and clinical nurse specialists. Well, of course, the first thing before you uh, subject someone to an involuntary hospitalization is they have to be mentally ill. What does that mean? Well, here's a fancy definition. You don't have to know it, but I want you to know this. I want you to know that there is a definition. Mental illness means a disorder of thought or mood which significantly impairs judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. The point of this is, the reason I show it to you is that it's not a DSM diagnosis. They don't require that you diagnose one of a number of conditions. So they give you a very general and very flexible definition. Your job is to describe your findings. Is the patient highly agitated, hyperverbal, threatening? Do they appear to be responding to external stimuli or internal stimuli? Basically hallucinating. Are they delusional? Do they have a fixed false belief that's outside their culture? And so forth. So describe these and use ordinary words if you can, technical words if you have to, but describe it. You don't have to have a DSM diagnosis. Do know that Georgia says that you cannot subject someone to involuntary hospitalization based solely on traumatic brain injury. Now, that's really not much of an exclusion because usually you can describe other findings that go along with that, but they didn't want the state mental hospitals to be filled up with people with brain injuries because there are no treatment programs in the state hospitals specifically for traumatic brain injury. Now, the time frame. How long is a 1013 good for? 48 hours. That means you need to get going as soon as you can. The clock is ticking when you sign that form. You need to find out as much information as you can. For Our Lady, you need to find out, if you can, where she lives, who's treated her, friends, church members, whomever you can get that'll help you figure out an appropriate treatment plan if she's to be discharged, or to complete a 1014 and make a plan if you think after 48 hours she's not going to be ready to be discharged. And again, analogous to the 1013 is a 2013 for substance abuse with a 2014 for the period after 48 hours for substance abuse. Now, sometimes happens, and it's happened to me a few times, where I might see somebody in an intensive care unit after some sort of self-inflicted injury, say an overdose, self-inflicted gunshot wound. And I see them following their admission and initial stabilization. They're denying that they made any sort of attempt to harm themselves. I'm not quite so sure. I need more time to assess this. They're adamant. They insist, you better let me leave here. And I've been told by people before, and even though I try to be nice to them, they're so angry about being kept. They'll say, you're never going to practice medicine again. If you fill out that form, I'm going to sue you and I'm going to take everything you have. Well, as long as you act in good faith, and this is again official code of Georgia annotated, you see the reference there. As long as you act in good faith, you are provided immunity in the law. Now, by good faith, that means that you're acting in the patient's best interest or the best interest of society, but you're acting as a good physician. How can you show that you're not acting in good faith? Well, there are cases where people have said things they shouldn't have said. I'll show him not to fool with me, or he's never going to do this again, or she's been coming in so often, we're going to teach her a lesson, or they say something like that, which then doesn't sound like good medicine and it doesn't sound like acting in good faith. So be very careful what you say. And if you're angry about the circumstances, debrief yourself if you can. It's like House of God, take your own pulse. Um, and if you have to talk with somebody to let off a little steam or maybe explore this, do it with someone you know very well. But be careful what you say. It's not professional and it can get you into trouble. But the ethics of involuntary treatment, there are some people who oppose involuntary treatment. They believe patients have a right to kill themselves, they have a right to go about with untreated medical conditions, even if it's life threatening, and if the patient is mentally compromised. Well, most of us believe, I say most of us, I believe, and I think there's an ethical basis for involuntary treatment based on the principle of beneficence. Implicit in this is that we believe that sometimes patients are no longer able to act in their own best interest, that they lack the capacity, we're going to get there in a little bit, to do that. They're so compromised by mental illness that we have to act for them. Now, there's a couple of other doctrines you need to know about. There's the doctrine of parens patriae, or father of the country. That is sort of a legal notion that says that sometimes we act to protect patients when they can't protect themselves. So that's related to the notion of beneficence. There is also, when patients are threatening others, the notion of police powers, that the state has a duty to protect other members of society. So if you have a patient who is representing a threat to others, then the state has the right to involuntarily hold someone, in this case based on mental illness. So we ought to have a mental illness before we do it. We can't just hold somebody who's threatening and put them in on 1013. There should be a mental illness associated with that. Otherwise, they could be charged with terroristic threats and held in jail, the LEC in Macon. But that's different. That's not the 1013 process. Okay, here's some final points on involuntary hospitalization. Just keep in mind, this is something we do a lot in emergency rooms and sometimes on medical floors. We get so used to it that sometimes we forget that we are taking away a fundamental right of an individual when we hospitalize them involuntarily. We need to keep in mind that this is a fundamental right, and that whenever we do it, we need to be mindful that we do it in the kindest, most compassionate way with patients. And that even the most psychotic patients frequently remember, when they regain their grasp of reality, they remember how they were treated. They'll know that they were hallucinating and they did some things which maybe weren't very nice, but they'll remember how they were treated. So please be professional and be kind, even when a patient is acting in the most bizarre manner possible. Okay, let's move on. We're moving into another topic now, and I'd like you to consider this case, which involves boundary issues. You're in the emergency room. You examine an attractive patient whom you've known for some time. Let's say you're members of the same church. You may have other social contacts. You notice this patient has become tearful when you ask how things are. You empathize. You ask what's the trouble, and the patient says, perhaps after a pause, I'd like to talk, but it'd be so much easier over a cup of coffee. It just seems so impersonal in here. And the truth is, emergency room have impersonal examining areas. That's true. What should you do? Think about it for a minute, and let's look at some options. Well, you could say, well, if that's how you feel, I guess there isn't much I can do for you. Well, that's certainly sort of dismissive and doesn't really put the patient's interest first. Would you like me to refer you to a psychiatrist? Well, that's certainly done sometimes. Many of you will work in areas where you don't have access to psychiatry, and that may be a step or two ahead of where you want to go. How can you explore things before you do that? That's not quite as dismissive as the first response, but it's still somewhat dismissive. You could say, well, coffee, well, there's no harm in that. How about after I finish here? Bzzz. That's probably the wrong answer. You certainly have crossed over a therapeutic boundary. Even though you might know each other socially and in other settings, consider the last option. This does seem a bit impersonal. I'm not sure I can do it right now, but how would it be if we scheduled a time in the next day or two to talk in my office? And that's probably the best one. It keeps the relationship within professional boundaries, both physical boundaries in the office, but also the interpersonal boundaries, that this is a medical contact you're talking about and not just schmoozing over coffee. Well, just think about this. That in our relationships with patients, it's sometimes hard to strike that fine balance between a compassionate, caring, humanitarian, yet fiduciary relationship with patients. It's a one-way relationship. We have to care for them as physicians. Patients don't have to reciprocate. Now, we'd like them to, and sometimes it's impossible if they don't reciprocate something. But it's a really pretty much a one-way relationship. And how do we balance that with uh, that sort of compassionate part with maintaining those proper boundaries without getting overly personal? What's the danger in having a personal relationship? Well, there's a number of them. The main one, as I see it, is a loss of objectivity. How can you be a really good physician? Treating a member of your own family, for example, is hard. Now, we all do it, and I've done it too. I prescribed amoxicillin when my kids had ear infections. Sometimes you do that. But in some personal relationships, there are questions you might need to ask, say, of an intimate nature, that you're more reluctant to ask when you become less objective and more personally involved. And that's just not good medical care if you don't ask the right questions. It might be hard to do parts of the exam. It might be hard to intervene most appropriately if we let our personal feelings begin to color the relationship. And I also just want to acknowledge a difficulty here that many in smaller communities or social circles, you're going to know a lot of people who are your patients. You're going to know them in other settings. And it's just an area of judgment. It's something we have to practice to learn how to maintain those boundaries when we know people in other settings. When I say social circles, you can practice in a big city like Atlanta, but your social circle will be much smaller. And so even in big cities, you'll have a good many patients that you'll see in social settings, grocery stores, churches, golf clubs, um, places like that, schools. Now, how do boundary issues arise? Well, one is, what do you talk about with your spouse or your significant other? It's so tempting at the end of the day to talk about patience because that's where we spend our lives. Much of what we learn is titillating, interesting. Well, one rule you should establish early on is not to talk about patients with your spouse or significant other if there's even the slightest possibility that they might identify them. It puts your patient, obviously, wouldn't appreciate you doing that, but it also puts your spouse or significant other in a difficult situation because then when they run into this person, their relationship will be colored by what they learned from this kind of inappropriate conversation. So don't do that to your spouse either. Let them know that person in their own way, and you don't have to color it with your own comments from what you learned. Another way this comes up very frequently is some of your patients are going to have, say, court involvement. It might be a workers' comp case. There might be an employment case where there might be a suit involved. There'll be a lot of reasons why you'll have patients who you have a physician relationship, but all of a sudden you find yourself doing something for the courts. Well, that's really a boundary issue because what you report to the court, even with the patient's permission, sometimes you'll be asked to divulge things that you think aren't really good for the patient. I might, for example, know a lot of background about a patient, about their sexual indiscretions, drug use. Well, once I start filling out forms and testifying for a patient, I can be, I might not be, but I can be compelled to divulge that information, which could be quite harmful to a patient. So, again, that's one of those potential boundary issues. Are you the patient's doctor, or now are you doing other things which could compromise your doctor relationship? When you work with patients and families, you'll find boundary issues coming up. If you're treating someone's child, well, the parents have a right to certain information, but as we'll see in a little bit, if it's a 15-year-old girl getting information about contraception, and the parents want to know about that, how much can you say? Well, it turns out that child has a right to information and even access to contraception or treatment substance abuse. There's other areas we'll talk about. And you have to be very careful, particularly when you know the parents and you think this is information that they would want to know or that you might want to know as a parent of your own children, but you have a relationship also with the child, and that's your primary relationship. Certainly, sex with patients is not a good idea. Um, so I think you all know that, but keep in mind that that is something that does happen too often. Business relationships with patients. You have a patient who's uh, either say selling cars and they offer to give you a special deal, or any other kind of business relationships, and you get special deals because you're their doctor. Be careful. How is that going to compromise your objectivity and your ability to be a good physician? Gifts from patients. I accept gifts occasionally. Patients sometimes at the end of a relationship or perhaps at a holiday have a need to express their appreciation and they give us small gifts. Those are okay. What is small, of course, is relative, but I think you know what they are. Certainly cards, a plant for the office. There are things like that that are okay. People have gotten into trouble accepting large gifts from wealthy patients. Don't do that. Again, it compromises your objectivity. And be careful in your relationships with colleagues. Are you getting a real, say, curbside consult about a patient, or are you just sharing titillating information about a case? Keep in mind that your boundaries and your respect for the patient extends even when you're talking with other doctors, if those doctors are not involved in the care of the patient. VIP patients are always an issue. We feel special when we're treating a governor or a high official or a very wealthy executive, and it kind of makes us feel more important as doctors. But again, it can compromise our objectivity, and we might not do things that are unpleasant for the patient. Um, so be careful when you're dealing with VIP patients that they are first of all a patient and only secondarily a VIP. Okay, ethically, the principles we're worried about are beneficence and non maleficence. We want to do the best thing for patients, we want to avoid harm, and we can do this the best way if we remain objective, looking at risks, benefits. What is good medical care? Is that patient continuing to get good medical care? Or has some sort of a boundary issue compromised our ability to give the best, most beneficent care? The patient autonomy can also be compromised in these relationships. If a physician is having an intimate relationship with a patient, that patient's ability to consent to medical care is compromised. They might feel so enamored of the physician that whatever the physician says is great. They might not be able to weigh the information objectively. So keep in mind that your patients also need to be able to have a less personal view of the medical situation in order to make their best decisions. All right, here's some take-home points on boundary issues. Anticipate them. Physicians, about half of physicians, by the time they reach roughly age 40, describe themselves as feeling burned out. They've seen the same patient population for too many years. They've kind of lost touch with newer treatments, and they're feeling burned out. And the possibility of a relationship, something developing with a patient, is sort of exciting. This is especially true if things at home seem to have gotten a little stale, and this is the opportunity they've been dreaming about when that attractive patient tells them they're the most wonderful doctor in the world, and they listen the way nobody else listens, and suddenly they're feeling things are getting spiced up pretty good, and their interest is piqued. Well, be careful about that in yourself. So think about um, where you are in your career and at home and how vulnerable you might be. Also, look for those warning signs in your colleagues. We are brothers and sisters. We need to protect each other. Are you or your colleagues spending more and more time, special time with patients, scheduling times after hours? Um, these are some warning signs that that patient has become more important, and the physician, you or a colleague, might be losing objectivity. And the best thing to do if you see something like this is to get a consultation. What is going on? Get some facts. Talk about it frankly with yourself, with a colleague, even if you're the one involved. Say, hey, look, I need to talk with somebody about this. Or if you see a colleague starting to get into what might be trouble, see if you can clear the air in a very gentle way, or have a trusted friend or colleague, somebody that um, can approach your colleague uh, and just find out what's going on. We're not doing any favors by keeping the kind of veil of silence in these relationships. Most physicians can pull out of a slump at home or a slump at work and not get themselves in trouble. Once they cross a line like that, that could be a career-ending move. Okay, here's another issue that comes up, mostly in the area of confidentiality. Sometimes it's also a boundary issue. It's one of these where you might have a dual relationship. Think about a patient who might be a depressed 29-year-old woman. She's in the middle of a child custody battle. An officer of the court comes into your office, sometimes wearing a uniform, with a subpoena demanding you turn over your medical records. Now, these subpoenas have a lot of fancy Latin on them. They sure look official. And our first inclination is to say, yes, sir, here they are. Let me make a copy and hand them over. But what should you do? Think about it. Here's some possible responses. Yes, you ask your receptionist to photocopy and turn over the records, noting that the court is responsible for such costs. I say, yes, I mean no. Don't do that. I do know practicing physicians who've done that. They're intimidated. They don't really understand that a subpoena is something that one side, in some sort of legal case, one side's gone to a judge, requested a subpoena, the judge has granted it, but the merits of that subpoena, of that request for information, haven't been fully argued. Both sides haven't been present to argue it. Well, you refuse to turn them over, stating that until you've had time to discuss this with your patient, the records are confidential, or in a legal setting, we call that privilege. That's a good response. All right. So in general, the principle where there's a subpoena, a request for records in a legal situation, the requirement is that you reply. You tell them what you're going to do and how you're going to do it. Not to comply immediately. You might comply after you've gone through a few other steps, but you don't have to turn it over, nor should you turn over your records immediately. You want to get in touch with your patient. Tell them, yeah, you just got this subpoena, and what's it about? Find out the circumstances. What's the suit about? You might review the record yourself and then advise a patient, well, you know, there's this other information. We got a pretty thorough history when we started. You told me this and that. Is that information you want released? Because patients, once they enter into certain kinds of actions, um, it's not always possible to edit records. Now, there is a way for judges to do this. It's called in camera or in chambers, and decide to use portions of the record but not the whole thing. But in my experience, that's unusual. Usually either turn over the whole record or none of it. Advise your patient to speak with the attorney. Let them know, gee, there is this background information there that might not be real helpful. Is it still a good idea to release this? If the patient and attorney both say this is what they want to do, be sure they sign a release. The patient signs a release of information before you turn over the records. Sorry, I jumped ahead a slide there. So keep in mind that you do have to reply. You can't ignore a subpoena, but you shouldn't go to the other extreme and just turning things over without talking with your patient and getting your patient's attorney involved. Okay, now we're going to go to a different situation, a special topic in confidentiality. And consider this case, and again, this is based on an actual case. So, a 24-year-old graduate student in naval architecture from India is brought to your clinic by a roommate who says he's concerned that Mr. Podar, the patient, has become obsessed by a female student. Mr. Podar has begun recording calls, been walking by her house several times a day, and today, after he approached her house, she told him to go away. He became angry, stating, "What she has done is wrong and cannot go unanswered." Mr. Podar is very polite when you see him. He denies wishing to harm anyone and stated he came as a courtesy to his Indian roommate, and then he asks you to leave. What do you do? Now, this case isn't exactly historical, but it has enough similarities to the real case. You probably recognize it. Well, what could you do? You could attempt to get Mr. Podar's permission to speak with the young lady, get her account of things. You could notify the police that he doesn't appear to be imminently dangerous. You can't hold him involuntarily, and ask them to contact the woman and to warn her. You could proceed with involuntary hospitalization, and there might be other options depending on the specific circumstances. So the first one is definitely yes, try to get permission. The second situation depends on your jurisdiction, and we're going to get there in just a second. The third is a possibility because remember, the 1013 is for evaluation. And in a case like this where the roommate has heard what might be threats to a third person, that could be sufficient grounds if you can find evidence of a mental illness. And perhaps the recordings do that and the walking by the house. You might have enough basis for a 1013. Well, of course, you recognize this is the case of Tatiana Tarasov. And this actually happened in the late 60s, several months after Mr. Podar was released from the clinic. He went to the house of Miss Tarasov. She opened the door and he shot and he killed her. Oh, I should also mention that in that case, when the therapist went to the head of the clinic, the head of the clinic was shocked that the therapist had notified the campus police trying to pursue an involuntary hospitalization, stated that he had breached confidentiality and ordered the records destroyed. I'm not saying that was wrong necessarily. Certainly today we're a little shocked by that, but that's after the benefit of having thought about the Tarasov case for many years. Family sued the University of California. This happened at the Cowell Student Health Center in Berkeley. And they found that the therapist should have warned Tatiana. Now, when they first heard the case, the California Supreme Court stated that there was a duty to warn, that in fact the therapist had a duty to warn Miss Tarasov in order to protect her. There was such an outcry over that breach of confidentiality that the California Supreme Court heard en banc, meaning the whole court reheard the case, and they modified their ruling to what currently applies in California, that there isn't a specific duty to warn, but there is a duty to protect when the therapist knows, or pursuant to the standards of the profession ought to know, that the patient represents an imminent risk of harm to a third party. Then they need to take such steps as are necessary to protect that patient, which can include, but are not required to include, duty to warn. So they can warn, but they can also take these other steps, notifying police, trying to get in touch with his permission to get in touch with Ms. Tarasov to bring her in and get her side of the story. There are other things a person can do, involuntary hospitalization. So it's really a duty to protect, and it's in California. Some states have passed laws very similar to the Tarasov duty to protect law. Some states have said, no, they aren't going to follow that, and that confidentiality is paramount. There's no specific Tarasov duty in Georgia. The best known case in Georgia actually involves a case where a therapist notified a police department of the violent dreams that a police officer had been having who'd been disciplined and was in therapy. The patient then sued and won against the therapist for breach of confidentiality. So it's unclear. The case wasn't heard by the Supreme Court in Georgia, so we don't have any precedent here. But one needs to be very careful. And my bottom line is that let's look at other options, including involuntary hospitalization, getting the patient's permission to contact someone, and so forth, before we actually contact someone without the patient's permission. Um, and getting a consultation on that's probably the best idea. We're now going to turn to the topic of informed consent. Um, and as you recall from the first year, the ethical principle underlying informed consent is the principle of autonomy, and Justice Cardozo best said this when he ruled in the case of Schlendorf in 1914 that every person of adult years and sound mind has the right to determine what shall be done with his body. Um, and this legal doctrine of informed consent had actually been evolving for some time before that. And the evolution accelerated in the 50s and 60s. And now in most states, except in Georgia, in fact, I think every other state has a doctrine of informed consent. Georgia does not. I'm going to say something about that in just a second. The three elements of informed consent, and this is important, are that there be adequate information pertinent to whatever medical decision is being made, that there be a competent patient, that is, the patient has sufficient capacity to make that decision, and that the decision be voluntary, that the decision be free from undue influence. But again, in Georgia, there's no general doctrine of informed consent, and consent is required only for major surgical procedures, amniocentesis, and radiographic procedures requiring use of IV contrast material. So it doesn't apply to many other things that we do in medicine in Georgia. All right, the information we give, though, I say this a little further down, right here, although general doctrine of informed consent does not exist in Georgia, act like it does. You're not going to hurt yourself, and it's going to be a good way of educating patients and facilitating communication, easy for me to say, and not just paperwork. And so in general, the kind of things we need to disclose include the nature of the condition, what it is we're treating, the nature of the treatment, what the alternatives are, the risks, the prognosis with and without treatment. The kind of stuff I think that is important for all of us before we make a decision. Now we talk about competence, but remember competence is actually a legal determination. Mostly what we do in medicine is we assess their capacity to make a decision. And it's very specific to that particular decision. A person can have capacity, or loosely we say be competent, to make a decision to have a venipuncture. They might not have the same capacity for experimental brain surgery. And actually, there's a case on point on that too. So we can have capacity for some things and not for others. We can have capacity to accept certain treatments, fairly low risk, high benefit, but to refuse that treatment would require a much higher level. I'm going to go over that again in just a second. Capacity, even though legally we talk about competence being there or not there, that is, there's only two states, capacity is best thought of as lying on a continuum, and that the lowest level of capacity is appropriate for interventions that carry the lowest risk and the highest benefit. And usually that just means, can a patient communicate verbally or non-verbally their agreement or disagreement with the decision. Mid-level is mostly where we are with capacity. That's the usual standard. So after we've talked with the patient about various risks, benefits, alternatives, prognosis, and so forth, we just ask the patient, we might say something like, I know I've been doing some talking here and I've told you a lot of things. Can you, in your own words, tell me what we've talked about? I'll give you a chance to clarify things. It's a process of communication. So that's usually what we do. In some cases, where a patient is either consenting to an experimental high risk procedure or refusing a fairly low risk procedure, then we would require the highest level of competence, which we consider an appreciation. So, have they thought about how this could affect their family members, affect them spiritually, and so forth? That's the highest level. It's beyond paraphrasing. And I sort of said this before, but this is really important. For a decision whose outcome is involves some high risk or low unknown benefit, the level of competence should be high. So, if you have a patient who needs a transfusion after a motor vehicle accident, a life saving transfusion, and they want to refuse that, again, the risks of that are fairly minimal, the benefits are very high. You would want a patient with very little compromise to their capacity. They should be able to appreciate the spiritual consequences and so forth. So, a higher level of capacity in a decision that involves higher risks. Obviously, for low risk procedures, we don't require much in the way of capacity. Voluntariness is the third element in informed consent. That just means freedom from coercion. Now, students sometimes ask, well, if a patient asks me what I would do, the physician, were I in their position, should I refuse to answer because that might be coercive? No, a lot of times I will answer. I'll say, well, I tell you, in your position with this to consider and that to consider, it's hard to say because there might be other things I don't know, but looking at all of that, it seems to me this procedure could be the one that might serve you the best. So yeah, I do give recommendations sometimes. Patients want that if they ask for it. I don't volunteer that information if they don't ask, because then that would be coercive. But yeah, sometimes I will share my personal opinions about things, about what I might do in their position as I understand it. And I should mention also in research, if we pay patients, particularly poor patients, too much money, that can be highly coercive. So this is where IRBs, the institutional review boards, needs to look at the level of compensation for participating in a research study so we aren't unnecessarily coercive. Consider minors. Uh, these are persons under the age of 18. In general, they cannot consent to medical care except under the following circumstances: if they are emancipated, if they're married, for example, or if for some other reason they're declared emancipated by a court. They've been living independently, working, and so forth. If a patient has a spouse who is a minor and the patient's unable to consent because they're incapacitated, that spouse can consent for them, even though they're underage. If the treatment involves a minor's child, then that minor can consent to the care of that child. If a minor is being treated for a venereal disease or substance abuse or a complication or illness arising from these, they can consent. Minors can also consent to care involving pregnancy, childbirth, or prevention of pregnancy, contraception. It's a little more complicated for abortion, and I want you to just look at the link below, and they discuss medical consent law in Georgia in more detail. There are exceptions to informed consent in emergencies. Sometimes we can't get informed consent, and we need to follow rule number 1, be a good doctor. When there is an advance directive and a patient is incapacitated, we can follow that advance directive. In a sense, they've given their consent to this already. And when there's a surrogate decision maker, the patient isn't consenting, but the surrogate decision maker is making the decision based on what the patient would have wanted had the patient been in a position to decide. And then there's this sort of tricky notion of therapeutic privilege that it can be permissible to withhold information from a patient if that information is too harmful. An example in psychiatry that comes up fairly often is We have an acutely psychotic patient who needs an antipsychotic. They might be a danger to themselves or others. And we don't always tell patients about the risk of tardive dyskinesia. That's a long term risk. Uh, Telling a patient about involuntary movements at that time might be unnecessarily harmful and might thwart any attempt to help the patient at all. So sometimes we withhold that information for a period of time. We just need to be sure we get back to it. We just don't use that as an excuse for not telling the patient about it. So therapeutic privilege involves withholding information if the risk of giving that information is too great. Last, I just want to mention one thing that just comes up, and I don't know where else it is in our curriculum, so I just thought I would throw it out there because physicians, like the rest of the public, hear about so called insanity defenses, and I just want you to know what that is. It's not just being mentally ill. And in Georgia, every state has their own laws, and the federal government has theirs too. There's a lot of commonality in these laws, and the history is fascinating. But to qualify for an insanity defense, which is usually determined by a judge or a jury, the defendant must be mentally ill. And again, the law doesn't define that except in the broadest terms, just like they don't define it except most broadly for involuntary hospitalization. So they don't say it has to be DSM, but they allow a range of conditions, usually those which are psychotic mostly. They have to be mentally ill, and they are either unable to distinguish right from wrong with respect to the act, or they have a delusional compulsion, which makes them unable to resist the act. So if a defendant believes, and I actually had this case, that the fellow walking ahead of him was going to turn around and kill him because an airplane flew overhead, and the airplane was part of the military, and there was a police officer standing at the side who was also going to join in and attack the patient. And this had been a long-standing belief of the patient, and they attacked that individual preemptively before that person could turn around and attack them. Then it makes sense that, yes, they were mentally ill. They had a paranoid psychosis, a delusion. It had been in place for a long time. Others were aware of this. It wasn't just made up to cover this assault. There was no other reason for the assault. It wasn't to get drugs. It wasn't under the influence of drugs. It wasn't to get money. Then that's the basis for a possible insanity defense. These are rare. They're not common. People think, oh, they use these all the time. Less than 1% of felony cases even raise an insanity defense. Over 3/4 of the time, they're not even contested. Both the state and the defense agree this person had a severe mental illness, as a result of which they either didn't know what they were doing was wrong, or there was some sort of delusion, which was the foundation for that. And they don't beat the rap. A study I did a number of years ago showed that defendants actually served many years for misdemeanors, when had they pled guilty, they probably would have walked from the courtroom because, based on time served while they were awaiting trial. So in general, they don't beat the rap by pleading insanity. There are these isolated cases where somebody might, but in general, they don't. That's the end of our lecture. If you have any questions, please feel free to contact me, Elliott, ELLIOTT _RL @mercer.edu. I would welcome your questions and comments. Thank you very much.